To speak a little bit more about this, Mpumelelo Zikalala, legal practitioner at Zikalala Attorneys, joins us now for the conversation. A very good evening to you, and thank you so much for joining us, Mr. Zikalala. So 2 of the 5 men accused of the killing of Senzo Meyiwa, telling police in their confession statements that they were paid 100,000 rands, as I mentioned, for the alleged hit. And the judge ruling that the confession statements were made freely and voluntarily. So it's considered a victory for the state, but in what way in particular?
Good evening to you and also to your viewers. Yes, it is a victory because it basically says I'm 80% to the finish line. It's just the extra 20%, which would be basically technicalities and putting all the pieces together. If there's a confession that has been accepted as part of the evidence, the probative value of that confession is now going to be tested, and the chances of it being thrown out because it's not probable or it did not happen, they are very little. So from the side of the state, it is a victory on their side, and they're going to lament the fact and make sure that they're able to deal with whatever allegations are contained in those statements. The only problem, though, that they're going to find is coming back to rationality, linking all the pieces together, and then providing information as to say, if you have a confession statement that you're going to rely upon, why then arrest all the other co-accused that are implicated in that particular confession statement? So in this case, and then the question would be, why haven't you arrested Ms. Kelly Kumar on all of this matter? Why are you only concentrating in these individuals that are in the witness box? Of course, they have carte blanche in terms of how they're going to deal with and prosecute their case, but then the question would be, why do it in piecemeals? Why do it in instances in which we are going to rely on the evidence of other individuals before prosecuting everyone that was involved or allegedly involved?
And I want to come to those in just a moment, but firstly, the fact that this was a trial within a trial, some of the information from the statements were redacted. Is this a technicality, or what was the reason or the rationale behind that?
It is a technicality. It all comes back to compliance basis, the one that says whatever evidence needs to be obtained or to be evaluated by the court must first suffice the admissibility test. Is it evidence that can be admissible? Then the question is, how did you obtain that evidence? Is it in line with our constitution? Is it in line with the Criminal Procedure Act? Now, in this case, in evaluating that, it is when the section 217 then comes in when it comes to admissions. So you then have to say, is this particular admissions obtained freely, voluntarily? The person was in their sound and sober sentence. There was no undue influence that was exerted on the individuals. If the answer to all of those is yes, and the information of the confession is made in front of a magistrate, despite even if the peace officer heard it first, but the magistrate must be there, then you accept that evidence as evidence, and then the second part starts in terms of the evaluation part of saying, let's evaluate whether there's any value that we can attribute to the admissions that have been submitted to us, to the presiding officer to evaluate at a later stage.
So back to the point that you had made earlier on about the weight or the significance of these confessions. So as they mentioned, the 2 co-accused that the hit was ordered allegedly by Kelly Kumalo, who was the mother of the child that she shared with me. Is the issue of motive something that the court would look at? And what happens to the implications of her role in it? Would the trial conclude before she is charged, or is that something that happens simultaneously? What determines that?
Well, motive does come in because what you want to do is, from a rational basis, you want to think what really motivated you to engage in this. Was it pure criminality? Was it a hit? What's the circumstantial evidence that is around it? And that has a lot to do with the type of sentence in which you are going to get. If it's a robbery, then the sentence will be a bit lighter. However, if you then engage in plot and engage in premeditated murder, then the sentence in which you are going to get is going to be much larger. Which then begs the question of saying, if you have a confession statement and you have a doctrine of common purpose, individuals coming together, wanting to commit a certain particular crime, one, bring all those individuals together and try them in the same manner so that you bring the evidence once and for all, and then you're able to move on from there. And that is what I think the defense is going to lament on, in their second bite at the cherry when it comes to the admissibility of the evidence or whether the evidence should be given any value, because they're going to come back and say, well, we haven't been given the reason by the court as to why they admitted that particular evidence. They ought to have done so, by the way, in terms of saying, what evidence did you look at to say that the evidence was given voluntarily and freely? What evidence did you look at when you say the person was in their sound and sober senses? When they are testifying to say, we've been driving around for an X amount of time, we were tired from all the activities of the day, we have gone from one place to another, and there are a lot of things that were happening in our mind. But most importantly, interrogate the question of, did you understand what you were confessing to? Did you understand, most importantly, the implications of such? I think that's where it's going to come in. Now, the state is going to have a bit of a difficult time unless they can come and redeem themselves in terms of coming back and saying, we want to explain to you as the court as to the motive of these particular individuals, but then we are going to tell you why we haven't prosecuted all the individuals that are implicated in this particular crime. If you're able to do that, then maybe the judge will then be able to piece all the pieces together and say, you are actually making a lot of sense. These people must be found guilty beyond reasonable doubt because there's no other explanation other than the explanation that's been provided to me by the state.
So things like phone records, because the allegations were that Kelly Khumalo did call one of the co-accused at the time. What role would they play in strengthening the case of whether or not this person would have been complicit and the intent would have been criminal?
That's where the corroborative evidence will then come in. Now, you state an allegation and you state a particular fact or sequence of events. And then you say, if I was there on that day, then these are the independent pieces of evidence which are going to prove that indeed I was there. So if there's any communication that has taken place, there are going to be those records within the telephone records which are going to be there. If there were any promises of money that were done between the two parties, in addition to the phone records, then there's going to be evidence of the money being wired from one account to another and the manner in which the money was then utilized. If it's cash, you can even go back and say, did any pattern change in terms of the patterns of those individuals pertaining to the cash that they wanted to get their hands on? If the answer is yes, then you come back and say to the court, it is much more probable that these individuals were engaging in these activities because this is the motive that they were driving at, which is why I'm saying I'm a bit worried when it comes to the state, because these are all the questions that they ought to have looked at in the initial stages of the trial. They ought to have looked at when those two dockets were then available in front of them. Take the most positive and most promising evidence that is in front of you, merge it together so that you are able to have a strong case, and not just a case in which is going to be dependent on the admissibility of certain confessions at a later stage.
All right. Just finally, Ntanzi mentioned in his account that 2 shots were fired and the second shot hit Senzo as the gun was pointed at him. This has been the million-dollar question since this whole matter arose. Who shot or killed Senzo Meyiwa? But it seems that is still not coming out. Is this deliberate?
I think it would also depend on whether what's happening with the second confession statement that is there. You might find that within that statement, that's when those type of details are going to be elaborated on. So then the court will take a step back and say, yes, we want to know the final details of what is happening, but if we can't, we can then be able to draw inferences from what has been stated. So if there are shells, for example, 2 shells that are found within the crime scene, then it can be concluded that, yes, 2 shots were fired. If there's only 1, then you can also conclude that despite the fact that only 1 shell has been found, it does not mean that whatever confession statement that has been admitted as evidence should be disregarded or taken as if it's not the truth. But what is going to happen is that the accused that are claimed to have drafted those statements are still going to go into the witness box, are still going to bring their examination in chief, be cross-examined, and re-examination may take place, which may then help to dispel whatever confession statements are in the presence of the court at the moment.
Well, thank you so much for your time and your insights. Mpumelelo Zikalala, legal practitioner at Zikalala Attorneys.